Welcome to the Consumer Corner. This is a podcast that focuses on protecting the consumer from corporate America. One of the things we're going to talk about is how different companies have harmed consumers. Sometimes these stories will be newsworthy. Other times they might fly under the radar, so to speak. We will also cover some legal topics. In today's episode, we will look at something called alternative dispute resolution. This is more commonly referred to as arbitration and mediation. For this episode, we will focus on mediation and how this can help or harm you, the consumer. Since this will be a bit heavy in the way of legal terms and the like, I have to put my disclaimer in. I am an attorney. However, at least for the purposes of this, I am not your attorney. Also, for every legal rule, there seems to be 100 or so exceptions. If you have questions for a specific case, I recommend talking to a licensed attorney near you or however you want to talk to them. Also, as many of us are learning, lawyers included, many of our rules are created by judges, not necessarily the legislature, and thus can be changed by judges pretty much whenever they feel like it. So what is alternative dispute resolution? Arguably, it is anything that involves resolving a dispute without going to trial. When I was in the Marines, there were a couple of mechanisms that involved resolving disputes that not only avoided trial, but also avoided really much talking or wasting time altogether. Though it was usually pretty effective both in time and cost, technically that would be a form of alternative dispute resolution, albeit not officially recommended or condoned. Not sure if it still goes on, but I suspect it does. Today, we generally use mechanisms called mediation and arbitration. So what is mediation? Mediation is where parties come together and discuss their cases with a third party known as the mediator. Ideally, this mediator is neutral. The goal is to get the parties to agree on a resolution. If the mediator is clearly biased, it will probably be a waste of time. Prior to the mediation, the parties, probably through their attorneys, will usually provide the mediator with some background info related to the case and their position, as well as any previous attempts at negotiating. This is also usually done, what we say, ex parte, which means the other side doesn't see what you send to the mediator. That doesn't always mean we share everything, but we might be a little more open with our knowledge of the facts. There's usually a confidential nature to the process as well. The mediator is not generally supposed to share anything you say or do with the other side unless you tell them to, or any other third party, or the judge in your case. There are probably some limits to this, especially if you make physical or other legal threats. I'm also very careful about who I trust, given that I represent consumers. So I kind of assuming that they're telling everybody, but in general, they're not supposed to. For mediation to be successful, it helps if all parties are there, not just the attorneys. Typically, each party, through their attorney, will make a statement about their opinion of the case and their interpretation of the facts. This might be the first time one of the parties has actually heard the other side's position and maybe even all the facts. Corporate clients will often let their attorneys handle almost all aspects of the litigation with little to no oversight. As you can imagine, attorneys, especially those working for corporations, get paid a lot more for continuing to litigate a case versus settling it. In many of my consumer cases, I would estimate that at least 95% of the damages and attorney's fees that are paid by the other side are the result of them being what we would call stubbornly litigious. One opposing counsel told me that it was okay if his clients litigated and lost so long as they learned something, quotes, learned something. Each time his client learns something, they have to pay his fees, my fees, and damages to my client. Seems like it would be a lot more cost effective to just treat people with dignity and respect, but I digress. So back to mediation. After the initial case presentation phase, we usually caucus. Pre-COVID, this meant the parties each went to their own room, met individually with a mediator. The mediator would go back and forth between the rooms and discuss the good and bad of each case and try to negotiate a little. Since COVID, much of this has been done over Zoom or a similar platform. This allows the use of virtual rooms. Generally, I have not found these to be as effective as the in-person mediations, but they are probably less expensive. And we have had some luck. Hopefully, the parties eventually come to an agreement. Sometimes the parties will come back together to memorialize it, but they may not. And the mediator may draft some language up so the parties can sign. This will depend a lot on the mediator and the parties. So when do you mediate? Who pays for it? And how much does it cost? Usually the parties will split the cost of mediation. Sometimes a court may order it, and it might be paid for under a local alternative dispute resolution service. In federal court, we've had magistrate judges that will do the mediation. These would obviously be the ones not assigned to your case. These are also free, at least for the cost of the mediator. As mentioned many times, it is free. In my experience, it usually runs a few $100s an hour per party for those that aren't free. And don't forget, if there's review time prior to the mediation, they will actually charge for that too. So the ones you get privately, usually they can get kind of expensive, especially for a consumer case. So how about the success rate? Well, maybe not surprisingly, the mediations that are not free have been the most effective. I think of only one time I was truly disappointed in a mediation we had to pay for. There was one other case that was required to occur prior to filing a suit as per a contract with a car company. The mediation was required, and the other side had lied to a judge to get an arrest warrant for our client who had purchased a vehicle at a buy here, pay here type of place. And they actually damaged the vehicle so it wasn't drivable, and then accused her of stealing it. Surprisingly, they, or maybe it was their attorneys, were not interested in actual mediation. We had to do it, though. It was just an artificial roadblock they had put in place, thinking her attorneys wouldn't keep going after them. For what it's worth, I'm glad they didn't. It ended up pretty nicely for her. Every other mediation that we did voluntarily through third parties, to the best of my knowledge, has either resulted in a resolution or gotten us close enough to get there soon after. The second best has been court mediation with the federal district courts. Usually the parties want to get it resolved, but a small, non-trivial amount of time. They're just there to not look bad and act like they're participating. And usually the mediator sees right through that BS and cuts it off pretty soon, and they tell us. I've had some magistrate judges who are the mediators there say some very interesting things about opposing parties and their attorneys while they were in the other room. Occasionally, we'll get a mediator that doesn't have any interest in a consumer case and acts like it is beneath them. We haven't had those folks twice yet, though, and I do plan to request another mediator if we're assigned one who has previously indicated they are not going to be neutral. But I would say if both parties want to mediate in this particular scenario, that it will be successful most of the time as well. The last common scenario is the court-mandated mediation that often occurs in small claims courts that have a contract with a local mediation provider. These are usually a dumpster fire. That's a technical term. The mediators mean well, but the parties generally don't care to mediate. And sometimes the mediators, despite their intentions, are not at what we call A-game material. There's no preparation. They just show up and you got a couple hours to mediate, maybe even 30 minutes to mediate. And usually these take all day in a normal scenario. And like I said, they're not really A-game material most of the time. Sometime I'm sure they are, but they don't really give the opportunity to show that. I've actually had one try to give legal advice to my client that was just flat wrong right after he said he could not give legal advice. If you're required to attend one of these and the mediator spends 30 minutes telling you how awesome he is, he's not that awesome. And you're about to see firsthand probably how unawesome he or she can be. And in fact, I can't recall a single case that was resolved when I had to participate in these types of mediations. So why would I mediate, and when should I do it? Well, you do it to get the case resolved. Litigation often takes years to fully resolve if there is no settlement. We've had quite a bit of luck once both parties appreciate the position they're in as far as winning versus losing. In our cases, once a defendant realizes that they stand a strong chance of losing, they're usually ready to settle. We just have to figure out the money. This usually occurs after the court has denied any motion they have to dismiss the case or claims. And I feel like many times their lawyers are making them think there's a chance of winning so they can keep fighting and billing, but once the order from the court comes out, and they seem to have a change of heart. And maybe the lawyers blame the judge and say that selling is cheaper than an appeal. I don't know. But once I've had a defendant want to mediate before filing an answer. That was pretty early. They just got served with a complaint and they were ready to mediate. Not that they didn't want to settle prior to getting sued. Maybe they didn't take it seriously. I don't know. But I think their attorney just wanted one last chance to bill, and he tried to disparage us in the mediation. It did settle, though, and our client seemed pretty happy with the result despite his rude comments. And while I didn't really care about the other side's opinion of mediation in that case or any case, it was a win for them as well. The money they would have paid my clients and myself, as well as their attorneys, could have been very significant if we were successful. And I think given the facts and the fact they were willing to do this before even filing an answer is a pretty indication we were going to be successful. You also may have to mediate as part of a contract prior to litigating a claim. This was the case in the car dealer matter I mentioned before. We had to mediate, and then we actually had to arbitrate too. But we'll talk more about arbitration later. So I'm going to steal an idea from another podcast I listen to that focuses on lawyer things like practice management, etc. They end each episode with a tip or hack from each person in the podcast. So I'm going to try and have a consumer pro tip for my episodes. And my consumer tip for this week is to stop paying people for taking advantage of you. Consumer prices seem to be going through the roof. If it is a staple you need, you may not have a choice. But if you don't need it, don't reward their behavior by paying the same or more than you were paying before for terrible service or a terrible product. Recently, I've changed my hotel brand. I try to use because Hilton is horrible. And I suspect Marriott's probably similar, but there's other options. I usually have diamond status, and now I'm lucky if I get offered a bottle of water that is 3 tiers below tap water. They won't clean the room. Breakfast is about 50-50 if it will be there, and they don't even apologize for it. Rooms are clearly dirty, sometimes disgusting, and the price has only gone up. So I try not to use them if I can avoid them. And the same for unnecessary consumables. If this country could take a month off from buying stuff we don't need, I think some of this stuff would fix itself. That said, I would give some deference to some of your smaller, locally owned businesses so we can keep those around. But we really need to stop rewarding these big businesses that are just taking advantage of us and their employees as well many times. And that's a wrap on today's episode. I hope you had a good time listening and maybe learned something. I'm always on the lookout for press releases or other reputable news sources about misdeeds of any company, any financial company that's harming consumers. So feel free to send those to me. Please leave a review about this episode if you were so inclined to do so. You can also find me on the web at theconsumercorner.com and cliffcarlsonlaw.com. You can find me on Twitter sometimes at Cliff_Carlson. You can find us on Facebook at The Consumer Corner, or myself at Cliff Carlson Law. And find me on Instagram occasionally at cliff.carlson.law. And remember to like and subscribe to the podcast so you do not miss any future episodes. Also, please share this episodes with others if you find it useful. And have a wonderful week.